When do I need an ALJ hearing for Medicare appeals? Imagine you've been denied coverage for a medical service you really need. You've already gone through the first steps, but the decision still isn't in your favor. When should you take the next step and request a hearing with an administrative law judge? Once you've received a decision from the Qualified Independent Contractor, or QAC, and you still disagree, that's when an administrative law judge hearing becomes necessary. You need to ask for this hearing if the QAC has denied your claim or service and you want a formal review. Another key point is the amount in controversy, which is the dollar amount still at stake in your appeal. For 2025, that amount must be at least $190. If your disputed amount is less than that, you might not qualify for a hearing with an administrative law judge. You also need to request this hearing within 60 days of getting the QAC's decision. The date you receive the notice is usually counted as 5 days after the notice date, unless you can prove otherwise. Missing this deadline could mean losing your chance for a formal hearing. You might want to have a hearing if you plan to present your case in person, by video teleconference, or over the phone. Sometimes, you can even ask for a decision based on the written record alone, without a hearing, if that's your preference. This hearing is the third step in the Medicare appeals process and is handled by the Office of Medicare Hearings and Appeals. The administrative law judge will review your case fairly and decide whether your claim should be approved or denied. They look at issues related to Medicare Parts A, B, C, and D, including eligibility and entitlement. To request a hearing, you need to send a written request that includes your name, Medicare number, appeal number, dates of service, reasons for disagreement, and any supporting documents. Make sure to notify all parties involved in the previous steps about your request. If you don't agree with the administrative law judge's decision, you can appeal further to the Medicare Appeals Council or even take the case to federal court. In simple terms, you need an administrative law judge hearing when you've gone through the initial appeal levels, the disputed amount is at least $190, and you want a formal review within the set time frame. This step helps protect your right to challenge Medicare decisions about denied services or claims.